Hi, my name is Mark Joseph and I'm a South Florida family law attorney. And you're here to learn about the new parentage laws in the state of Florida. So some time ago, I made a video talking about all the overall changes that occurred as of July of 2023 to the Florida statute as it relates to family law matters. In this video, I'm going to discuss the changes to the parentage laws. By parentage, I mean the laws that discuss when paternity or other parental status is established between two parents. Now, these changes are very important because a lot of how cases and family law matters used to be addressed prior to July of 2023 has overall changed. And a lot of the new laws affect what rights both parents have either on the onset of the birth of the child or through subsequent litigation or adjudication matters. But before we dive in, please like, subscribe, and hit the notification bell to be updated when we post new videos. So, in the state of Florida, when we discuss parentage, we tend to discuss it from two scenario points. Essentially, the unwed mother versus the wed mother. Depending on these scenarios, really determine how much rights each parent has. So to get it out the way, if a mother is wed at the time a child is born, it is automatically presumed that her husband is the legal father of the minor child. Much of that law doesn't really get changed here. What we're going to focus on is the situation we have an unwed mother who gives birth to a child. Prior to July 1st of 2023, Florida statute 744.301, the natural guardian statute, would describe the rights to the parents roughly as follows. If a woman is married and gives birth to the child, the husband would be considered the legal father, and they both would be co-natural guardians, so to speak. However, if an unwed mother gives birth to a child, it is presumed that she is only the natural guardian. So regardless of knowing who the father is biologically, the father signing the birth certificate, or any of these situations, the mother was declared the only natural guardian. This is one of the major changes which occurred in July 1st of 2023. So now the statute reads a bit differently. The statute now says the mother of a child born out of wedlock and a father who has established paternity under Florida statute 742.011 or Florida statute 742.10 are the natural guardians of the child and are entitled and subject to the rights and responsibilities of parents. Now, with this new change, this allows for the automatic establishment of at least a natural guardian status between both parents. So the question now is, what does Chapter 742.011 or 742.10 say about establishing paternity? So 742.011, that is what we typically would have considered the statute in which you would previously have filed to establish or determine your paternity. Just a reference, determine paternity is what you do when you have not established a legal natural guardian status for the minor child. You would file the petition to establish paternity in the past when you had already received that status of paternity, whether it be in a child support action or something similar. And we'll discuss that more where we talk about 742.10. So what 742.011 basically says is if you file that action in court, now it's something interesting that you should note in 742.011. It technically changes the type of proceeding you would file once you already have your paternity status determined. We would have typically called that the establishment of paternity. However, in the new statute, it specifically gives it a new title. The new addition to Florida Statute 742.011 now states, after the birth of the child, a parent may request a determination of parental responsibility and child support, and for the creation of a parenting plan and timesharing schedule pursuant to Chapter 61. That is essentially, although it's not official within the new forms and whatnot that's come out yet, that is the official new title for these type of proceedings. So what this says, when you count the natural guardian statute in 742.011, it now states that through that proceeding, you can establish your natural guardian status. So once the child is born, a filing can occur to make that decision, make that determination. And that's the very typical way that you would see cases of paternity be established. That's what I talk about in a lot of my previous videos. Where the change really occurs is in 742.10. The reason why the change to the natural guardian statute is so important is because it allows for the potency and strength of 742.10. The biggest issue prior to July of 2023 was we would have situations where you would have an unwed mother be in a relationship with the father, get pregnant, the person she's in a relationship with is the father, they have the child, he signs the birth certificate, which in turn typically means in the state of Florida that he has signed the acknowledgement of paternity. He would do all these things, be active in the child's life, and once there's a breakdown, maybe a breakup, he would come to find out and realize that none of his rights were established, even though he's done all the steps that you would typically believe would give him those rights. Now, because of the natural guardian statute change, that action of signing the acknowledgement of paternity, which would get him on the birth certificate, now establishes him as a co-natural guardian. This is huge for fathers in Florida. This now means that from the onset, you don't have to file an action to be able to have decision making in a child's life, to be able to have time sharing in a child's life, to be able to be on medical records, be on school records, to actually deal with on equal footing the other parent. And most importantly, when you come to legal actions, this limits or basically abolishes situations where one parent, the mother typically in this scenario, can get a pickup order against the father solely because she would have been deemed the natural guardian. But to be clear, this only occurs if the father has established paternity pursuant to that statute. So we're going to talk about how you establish paternity consistent with Florida Statute 742.10. One of the ways you can establish paternity pursuant to Florida Statute 742.10 is through an adjudication through a proceeding. What's considered a proceeding? It can be an administrative child support case that's brought by the Department of Revenue pursuant to Florida Statute 409.256. That's typically known as the basically child support court. And typically, if you went through a case there and they issued an order putting you on child support or father on child support, they have to determine that you are the father before they can do that. But by virtue of doing that, you have now been established as the father. Doesn't mean you have all the rights, but you're at least established. So now you can go file that subsequent action. But that's how the establishment occurs. Another way can be through a proceeding that involves inheritance. Another adjudication proceeding would be dependency under a workers' compensation or similar compensation program. Chapter 39 proceedings, which is normally dependency proceedings, or Chapter 63 proceedings, which is adoption. So the other ways is through an affidavit, which can be signed by both parties and filed with the clerk of courts. Both parties signing that affidavit would also establish paternity. The other way that you establish paternity is essentially what I described with the birth certificate, getting on it, which is the acknowledgement, which in more formal context is a notarized voluntary acknowledgement of paternity. It has to be witnessed by two individuals and signed under the penalty of perjury. Typically, for those who may not be aware, there's a Department of Health form, DH 432, that contains a lot of this information. It has the same requirements. That is the form that is typically signed to get on the birth certificate. Now, some minor housekeeping context for the signing of an affidavit acknowledgement. It can be rescinded within 60 days after signing or the date of any sort of judicial proceeding to establish support where the signatory is a party, whichever is earlier. So in reality, you can rescind it, but you have 60 days from those two actions to do so. After 60 days, it shall constitute an establishment of paternity. It may be challenged in court only on the basis of fraud, duress, or material mistake of fact with the burden upon the challenger. This is a very important context of the law. For purposes of right now, we're just going to sit and stress the fact of how to get on to paternity. If you guys want to see a video about disestablishing paternity, let me know in the comments, send emails to us, and we'll get that going for you. So overall, after July 1st of 2023, the new law essentially sits as this. If an unwed woman has a child and the father or putative father, the person who believes they're a father, signs the acknowledgement of paternity or otherwise establishes their paternity via the ways they allow via statute, they are both considered the natural guardians of that child and both have the rights and responsibilities towards that child. That is a huge change from the way it was before, where no matter what essentially happened in any of those establishment proceedings, the mother was considered a natural guardian of the child, which could essentially, no matter how involved the father is, their rights were limited. So if you or someone you know has a paternity, child support, or even divorce matter, and they want to consider legal representation, please contact our office. We'll do a free case evaluation, set you up for a consultation, and see how we can help you. And if you or someone you know can use this new information, please share this video and also like, subscribe, and hit the notification bell so you can be updated when we post new videos. My name is Mark Joseph. Thank you for watching.